of course, we will dive deep into the issues of today's episode. Of course, first, we'll look at the issue of the Rivers State House of Assembly, judgment by the appeal of recently delivered. You can all agree with me that it has been an ongoing issue, but the Court of Appeal, of course, recently delivered their judgment, which seemed to, cause jubilation in the two camps that are fighting for this. So, what do you make as a legal mind, legal practitioner? What is the purpose of this judgment that is causing jubilation for the two camps that are fighting?
Thank you very much. It is clear that politicians will always want to please the gallery. And if there's a decision or judgment or ruling, they will always want to give the impression that it favors their cause. Now, looking at what has happened so far, what happened is that there was an order by the Rivers State High Court declaring the seats of the former Speaker, Martins Amawile, and 25 others vacant for their defection from the party on the basis of which they were elected. And then when the court now ordered them to stop parading themselves, they now went to Court of Appeal against that ruling. And the Court of Appeal last week delivered its judgment. And what was the basis of the judgment of the Court of Appeal? The issue that the Court of Appeal looked at and decided is whether the High Court of Rivers State has jurisdiction to entertain the matter in the first place. Of course, we know that jurisdiction is fundamental in any proceedings. It is the lifeblood of any action. Where a court lacks jurisdiction, it cannot adjudicate. And if it goes ahead to adjudicate without necessary powers to do so, whatever the court may have done by way of judgment ruling is null and void. Now, the Court of Appeal has gone ahead to deliver a judgment to the fact that the Court of Appeal said that the Rivers State High Court has no jurisdiction to entertain that matter. That the court with the requisite jurisdiction is the Federal High Court. That is what the Court of Appeal said. And to that extent, where the Court of Appeal now came to the conclusion that the State High Court has no jurisdiction, the consequential order is to set aside the orders made by the High Court of Rivers State as say was made without jurisdiction. And that is all that the Court of Appeal did. The Court of Appeal did not restate the former Speaker and his group, as some people are claiming that the Court of Appeal did. What the Court of Appeal said that the High Court to entertain and educate on this matter is the Federal High Court.
All right. Of course, the Court of Appeal decided on jurisdiction. So, Barrister Deji, Barrister Deji have said that, of course, he has explained what the Court of Appeal, but there are still some lingering issues surrounding this. Because he talked about consequential orders, of course, which, of course, if the court has said that what the court decided they should stop parading themselves, that means, does it now imply that, of course, that they can continue their work as Rivers State House of Assembly lawmakers? What is the consequential orders therein?
Well, thank you very much. I'm not too sure that the court made any specific order on the legal status of those who defected. No. There was no such order. No such order as at now. The court did not and all that the court said is that, look, that judge do not have jurisdiction to entertain the matter. And ordinarily, if you look at the provision of the section, well, if it had been, and that's the problem we have, the High Court does not have the powers to transfer matters to the Federal High Court. But the Federal High Court, under Section 22 of their law, can transfer matters to the State High Court if the court found that that matter ought to have been properly entertained by the State High Court. In this case, the order was made by a judge of the High Court. And what the Court of Appeal said is that that court has no jurisdiction to make an order to the effect that they should stop parading themselves as members of the House. But it does not mean that the court had validated the act of defection. It does not mean that the court had restated the defected members. So it's a question of jurisdiction, and that's what the Court of Appeal has dealt with. And of course, you know that the provision of Section 109, subsection 1G, that is in question in this matter, that provision of the Constitution is automatic. It doesn't even require any specific performance or any order. The provision of the law is that once you have defected from the political party through which you came into the House, in the absence of any merger or in the absence of any division in your party, automatically you vacate your position. So that position is still there. Now nobody induced them to move from their political party to another party, and they even made a fun fear of it. It was on tape, or they recorded it. They even made copious averment in various suits that are still pending in the federal. There are other suits that are pending in the federal court, even on these matters.
Yeah, but if you say it's automatic, so what is now the essence of them going to court?
They went to court to try to restate themselves, and I don't know the basis upon which any court will give such an order, because the provision of Section 109, subsection 1G, is very explicit.
No, but if you say it's automatic,
yes.
Some people have cited an example in the past where people defected and they still retain their seat. So if you say it is automatic, how is that?
Yeah, the Constitution makes provision. The Constitution makes provision for circumstances under which you can retain your seat.
No, we are saying
that provision. Now, a court cannot give an order that is patently inconsistent with the provision of the Constitution. Otherwise, what you have is anarchy. The provision of the Constitution does not require any interpretation. It said the member of the House shall vacate. Shall, the word shall there.
We saw Dogara, Saraki, and some other people defect in the past.
If there is a division in the political party, if there is a division or there is a prospective merger between the party, obviously that proviso allows for a member to change his party.
So who now determines if there is a division, there is all of those things? Because I'm sure that one will be a question of fact.
Yes, in terms of defection, when, like the Electoral Act says, that where a person is elected, it is actually the party that won the election. Which means that if somebody has contested on the basis of a political party and as one is, the victory is for the party. In terms of this River State crisis, the people that defected were elected on the platform of PDP. Now, they defected, and the provision of Section 109, 1G is very clear. Then where a person defects from the party on the basis of which he or she was elected, that he will lose,
shall vacate
his seat, unless there's merger or there is serious crisis in the party known to everybody. Now, as far as I am concerned, there is no serious crisis in PDP to warrant them enjoying the exception to that provision of the law. Now, when there is such defection, what happens? What is the proper procedure? The procedure is for the Speaker of the House to declare the seats vacant. Now, among those that defected was the former Speaker, Martins Amaule, and 24 others. He was actually a former Speaker, but when he defected with others, the remaining ones now elected another Speaker.
Even though there are 2 or 3.
The remaining ones elected another Speaker, Okojumbo. And he now declared the seats of those that are vacated vacant. Those that defected, he declared their seats vacant. And then the question is there a way for them to wriggle out of this constitutional provision? My answer is no. For example, in 2012, a member of Labour Party in Akure who defected from Labour Party was sacked by the court, even though the case lingered up to the Supreme Court. The Supreme Court said so long as that member defected from the party on the basis of which he was elected, that he must vacate immediately, in compliance with the provisions of the Constitution. A similar thing also happened in 2022, when the Federal High Court in Abuja sacked 16 members of Ebonyi State House of Assembly for the same reason of defection. So in 2023, it also happened in Cross River State when 18 members of the Cross River State House of Assembly defected and they were sacked by the Federal High Court. So my take on this is that yes, I agree with the ruling of the Court of Appeal, judgment of the Court of Appeal, that the proper court to entertain the matter is the Federal High Court, not State High Court. Now, the Court of Appeal has been said that the proper forum for ventilation of this matter is the Federal High Court. That does not, by itself, restate those whose seats have been declared vacant.
Yes.
The proper thing now, in the sequence of this, is for INEC to conduct a by-election to fill the vacant seats. Although I'm aware that the affected parties, those defectors, went to Abuja Federal High Court and got an order, which, they claim reinstated them or ordered them to continue and try to stop INEC from conducting a by-election. And that is why we are saying that there must be sanity in the judicial system. There shouldn't be conflicting orders. Now, where a person has violated clear provisions of the Constitution, now can a court by itself decide that the person or persons concerned should retain their seats in clear violation of the provisions of the Constitution? The answer is no. Now, there was an issue you raised earlier, that the governor and some other persons, defected and then nothing happened. The one thing about our legal system is that if somebody has defected and nobody challenges it, then it may remain. The law does not go about looking for people who have defected. Someone must initiate a process. Maybe compel the speaker to declare the person's seat vacant, and then set the poll in motion. If maybe after someone has defected and the speaker concerned keeps quiet and then nobody does anything, the person may. You understand? But if somebody takes the matter to court, of course the court will say that having defected in line with the judgment of the Supreme Court on this matter, that person's seat is lost and lost so long as the person has defected. Yes, there are decisions where the Supreme Court has said that once you defected from the party on the basis of which you are elected, then you are lost your seat. And now, why are these people still trying to cling to their seats after they have defected from PDP? And we own that the provision of Section 109(1)(g) is very clear. Is somebody trying to play politics with the Constitution? Or what? The law is clear. You defect, yes, you are free to defect to any party you want to. But the party that sponsored you, on the basis of which you won that seat, will now get a replacement for you.
All right, Barrister Obiora. But Barrister Deji, let's also look at it from this angle. Because there seems to be a little bit confusion on the process of this declaration, defection, because you saw clearly that both parties were jubilating online, that they won, the case, that they have been reinstated. And even on the populists, you have explained very clearly and succinctly that once you defect, the speaker declares your seat
vacant. That's the procedure law.
Vacant.
Yes.
And that's what the constitution. So at that point, your seat becomes automatically vacant. At
Yes.
that point, the speaker. So the party, the other, the lawmakers who their seat are declared vacant. Of course, the constitution gives a proviso where you can defect if so and so happens.
Mm-hmm.
So if they feel aggrieved,
Yes.
they can now go to court to say that I defected because of
Any of the proviso.
those provisos.
Yes.
That the
Yes,
constitution.
yes. If they do so and you go to court, the burden will be
On them
to prove
to establish it.
that actually any of those two exceptions existed.
So the question is, as at the time they are going for the approach to the court, is their seat still vacant? Can INEC go ahead to conduct an election when there is still issues to be determined as to the reason why they defected? What does the law say in all of it? Because I'm sure that this is where we are. There is a kind of confusion. What does the law say when there is this gap? The speaker has declared their seat vacant. They are contesting that this or this, those provisos were the reason for their defection. So what is the status? What is their status within that time?
Now, let me first of all say this, that it is only the court that has the final say as to whether or not the provision of section 109(1)(g had been violated. Because obviously there's a general rule there and there's the exception. So the court is the only one that can determine whether that provision has been violated. Now, coming to the issue of INEC. Now, INEC is supposed to be a party in that suit. But where INEC is not joined, they also have a right to join in any of those suits. So that the order that will be made, the final order, can be binding on them. They can apply that to that. And where that is not done, and in many of the cases, then it will now be the final order of the court that will be served on INEC. Before INEC on their own cannot just go ahead to conduct by-election just because those seats had been declared vacant. Because the question of, and the interesting part of it is that the provision of section 109 did not even conceive of any order or any relief of any kind. It only says those the members of that house shall vacate, meaning that on their own they are not supposed to even say that they are members anymore. Immediately you change your party, just go home. That's what the constitution is saying. Don't come back to that house. But you know the way Nigerians are, they will still want to ventilate the provision, the implication of their own action, their own voluntary action. Nobody forced them to leave their political party to join another political party. And they made public pronouncement to it. They invited the press, and they have not denied it, even in some of the affidavits that are in the court, that they actually moved from their political party to another political party. So the question is whether our court will do the right thing. And
the question is,
yes,
at this point, when their seat has been declared,
yes,
and they have approached the court to
yes,
say that one of the two provisos, of course, that would be the reason why they have gone to court.
Yes.
To say that their seat was illegally declared.
That's for the court to decide.
Now. What is their status at that time?
Let me come in there. You see, one thing is clear. The issue of their defection is not a conjecture.
No.
It was something that was made public. Now, having defected, the Speaker of the Rivers State House of Assembly, who was elected after their defection, now declared their seats vacant and is the presiding officer in the House. So long as that declaration by the Speaker still stands, they cannot parade themselves as members of the Rivers House of Assembly.
And that is
a court of competent jurisdiction decides otherwise.
And that is why they are shopping. That's why they are shopping from court to court, looking for a court that will validate their defection.
In essence, they are not members.
They are not members
until any court, because they seem to feel that
they are not
members until a court says
no.
But according to your explanation, they are not members.
They can't be members. Otherwise. They can't be members of that house anymore.
Because have been declared vacant.
Because that is where, because we need to understand this clear legal provision.
Yes.
Of course, they feel that they are members until court says otherwise. Of course, the pro-Fubaras lawmakers, as they are called, feels that they are not members until the court eventually says they are members.
Yes.
They are no longer members of that house. They are no longer members. And that's why they are going to court anyway.
Other members of the House of Assembly, the remaining members are called on INEC to conduct a by-election. If those that have defected, they still want to contest, they are still free to contest. If they want to.
They can't contest.
But the issue is, so long as the seats have been declared vacant, the seat remain vacant until that declaration is set aside by a court of competent jurisdiction. And for that to happen, the burden lies on them, because they say he who asserts must prove.
Must establish.
The burden lies on them to show that yes, even though they defected, there are reasons which enables them to take advantage of the exception in section 1091G, the exception there. But then, as Nigerians, we will know what is going on. I'm not aware of any major crisis in PDP, or any matter for that matter, that warranted their mass exodus from PDP.
I think they tried to give an explanation on the question of problem in their political party, crisis, and they said because there was a suit in respect of the appropriate who should be the Secretary General of their party. That matter is in court. That was why they defected.
And their opponents say that the existence of a suit does not translate or tantamount to a crisis
in the party.
Has gone to court for the court to declare who is authentic party or chairman of a party, that does not mean
that's not a crisis. That's not a crisis. That's not an internal crisis.
So in essence, their seats remain vacated.
Now, on the issue of the INEC, you raise the issue of the INEC.
Yes.
Now, I think what INEC needs to do is not to hastily conduct election while the suits are pending. They need to wait for the final outcome of the decision of the courts of competent jurisdiction, and that court will now be the Supreme Court in view of the plethora of cases that are now in courts. There are not less than 3 cases in the Federal High Court on the subject by people who are members of the House and people who are not members of the House.
So that's the correct process, because obviously people are worried that if INEC goes ahead to conduct another election and the court eventually reinstates,
no, that will not be proper. It will not be proper for INEC to hastily go into conducting an election at this point. They should wait until the Supreme Court had made a decision one way or the other on the matter. That's when they can too sure, because that's the apex court. Obviously, most of those cases will go to the Court of Appeal and from them also to the Supreme Court. Of course, this particular one we are talking about is already before the Supreme Court. They have already appealed on the judgment of the Court of Appeal. But yes, the judgment of the Court of Appeal.
Yeah, but it's not the substance of the case.
It doesn't matter. They have appealed on the question of the legal status, whether that judgment still, whether it has the effect of reinstating the members, notwithstanding that the court said that particular court has no jurisdiction.
Then what the court of appeal said is that the High Court has no jurisdiction.
That's all that they said. So now I think the government, Fubara, and those who went to court, who went to the State High Court, are now moved the case to the Supreme Court on the question of whether the effect of that order will affect the status of these members of the House.
Do they actually need to do that?
That's another issue entirely.
That may not be the issue that the Court of Appeal decided. Except they want to raise new issues at the Supreme Court. The Court of Appeal decided a very
jurisdiction,
issue,
very narrow,
which is jurisdiction, which was decided.
And I think why they went to that court is because if you look at the nature of the order that the Martins Amewule's group, the pro-Wike group, took to that court, to the Court of Appeal, was the order of the lower court that they should not parade themselves as members of that house. So if, for instance, the court says that judge has no jurisdiction to make that determination, their own argument is that it follows then that the order made that they should not parade themselves is rendered nugatory. Yeah, that's their interpretation. Yeah, that they cannot parade. That they cannot parade themselves. Yeah, but that's their own interpretation.
But from what you guys have explained to now,
yes,
it means that it is not even the court that declared their seat vacant.
Yes, it's not the court. That's where that is the point. So that is the point. It is the house.
It is the house that declared their seats vacant. Now, of course, when the Court of Appeal said the High Court has no jurisdiction, it means the orders made by the High Court is automatically,
so
validated.
Does it not mean that they should, if the court says that not stop parading yourself, does it not mean
to the statement?
No, not the statement now. If the order was stop parading yourself,
yes,
as lawmakers,
and that is vacated,
that has been voided. Stop parading yourself has been voided. Does voiding not parading yourself mean start parading yourself?
That is the issue now.
No, because the declaration of the seats vacant still stands. The fact that and
it's an act of the house, not the act of the court. It's an act of the house.
I'm also aware that one federal high court in Abuja, sought to give order that has the effect of, validating.
They are already on appeal.
Membership of the River State.
They are already on appeal also on that one.
They have appealed against, and let's wait for the Court of Appeal to decide that matter, because on the face of it, the reason proffered for defection does not, as far as I'm concerned, meet the minimum requirements of the provisions of Section 109, such Section 1G. And to that extent, their seats, as far as I'm concerned, remains vacant. And I ought to, conduct a by-election. But I believe that the Court of Appeal will decide on that. And then at the end of the day,
but that says until all the court issues,
until the Supreme Court gives a decision one way or the other, because the matter is sub judice, as it states.
We are aware of the doctrine of least spending, that if the matter is pending in court, parties are supposed to maintain the status quo pending determination. But then when will the matter finally be over? It's when both this one and the one that the Federal Court in Abuja gave, that is presently pending and they're going to pay, when all of them are finally decided, it must still take a show. But of course, political matters
sometimes resolved politically, but not for judicial issues.
Just hearing at the court, both at the Court of Appeal and Supreme Court. I believe that
I want to say one final thing quickly before we leave this matter. Our courts should be careful of giving political judgment in cases like this. Political judgments that are patently inconsistent with the provisions of the Constitution. They are not good for our democracy and they should not be entertained.
Yes, but before we move into another topic, we go in a short break. Do you have anything to say? Because we've discussed this issue of contradictory judgments in the past and how the judiciary could help, in solidifying our democracy.
Yes,
what we are seeing, on the right, we continue to see reoccurrence.
I agree with you that in the past we've had we've seen conflicting judgments, orders, and decisions, especially in political matters, where one court on the same matter will give another court of coordinate jurisdiction will give a different order. And it is not good for our legal system, it's not good for the judiciary, it's not good for the nation as a country. Because in some cases, the parties affected are put in a fix as to which order to comply with and which not to comply with.
Yes, apart from the fact that it is not good for our democracy, are there no punishment as the senior member of the judiciary? Are there no punishment, of course, for a state high court to give an order in case he knows that he doesn't have jurisdiction?
Yes.
Are there no consequential punishment that for such errant decisions?
Well, to that
Or
question,
would you not propose? Or would you not propose what?
NJC has, in the past, punished some judges
Yes.
for giving ex parte orders that are conflicting. In fact, not quite long, they punished 3 judges for giving conflicting orders on the same subject matter. Now, the issue of a state high court now, like that of Rivers State now, giving an order. You see, it is a lawyer that filed the suit at the state high court. And having initiated the process, the court door is always open. But now, like what happened in Kano State. In Kano State, somebody went to the federal high court to get an order, ex parte order, in respect of a matter that has to do with traditional institution, traditional stool, because the MA is a traditional stool, traditional institution. And what it means is that it is not the federal high court that has jurisdiction on the issue of the Emirates tussle. It is state high court. But somebody has gone to the federal high court, and federal high court issued an order, and the other party has gone to challenge the jurisdiction of the federal high court on that matter. And if you look at it very well, the federal high court does not have jurisdiction. At the end of the day, I know that it's most likely the Supreme Court will say, no, we don't have jurisdiction. So, in the issue of where there is no conflicting order, so to say, but somebody has gone to the wrong court, well, it didn't start today. It's been there. It may not be enough to punish a judge by the NJC, but where a judge looks at a matter, I know that he or she doesn't have jurisdiction, but goes ahead, maybe because of other considerations, apart from enthronement of rule of law, democracy, and constitutionalism, then the NJC may wield the big stick. So we need to kind of distinguish between where a lawyer who has taken a matter to a court, maybe he doesn't know that court is not a proper forum for regulation of the grievances of his client.
But the judge should know. The judge should know that this case, I don't have jurisdiction, and he should disincline himself from entertaining it.
Is it not the first test for you to be a court to know the matter?
You must know your jurisdiction as a judge.
Before you.
Now, in this, now we have received in recent times the one of Rivers State, where the High Court judge gave order. Well, I've seen also in Kano State, where the High Court gave order.
From even the US. Because the judge was in the US when he made the order.
Yes.
Yeah, but that's what we're saying. Is it not enough to, because we are talking about sanitizing the judiciary as a partner in
yes, it's necessary that, you see, and you see, it's because of these things that the judges are made to undergo continuous legal training.
Because at the end of the day, we have confusion. Somebody can easily go to even a magistrate court, for a court that ought to start at the appeal court. And at the end of the day, the way he gives an order, and that order needs to be vacated before you even start the main substance of the case.
Yes, it's part of what we are advocating, that the judicial system need to be sanitized. Judges should know what matters they have, because federal high court, for instance, are courts of enumerated jurisdiction. The Constitution has clearly, in Section 251, stated the matters that the federal high court can entertain. The federal court was initially called Federal Revenue Court. Later, it was now changed to Federal High Court. Then the jurisdiction was enlarged, not confined to revenue of the federal government. Then the jury was, but it is still court of enumerated jurisdiction. And they ought to know what matters come within the confines of their jurisdiction.
All right. Of course, the court ought to know what matters comes within their jurisdiction. Of course, that is basic and that is fundamental.